Please unmute yourself.
They're unable to unmute.
Yasmin. Yasmin, please unmute now, please.
Johnson, you can also
Yes,
do
sir.
that.
Good evening,
Yes,
sir.
yes.
Good evening,
Yes.
ma'am.
Good evening. Yasmin, is 6th January okay with you?
Yes.
Okay.
Will you please give me 7th Jan, ma'am? 6th, like I'll be not
Okay.
here. 7th,
Okay,
I'll be okay
okay.
with.
Okay, then I'll check
Okay.
with Johnson. In the meantime, I think 6:05 we'll start with
Yeah, no problem.
Shiraz
Or
sir.
else otherwise next week we can do it. No problem.
Okay, okay. Thankanjan sir, can we start?
Yes, yes, we can start now. Please.
Shiraz sir.
Johnson, yeah, you can unmute now.
Oh, yes.
Thank you.
Yeah. On 7th of January, ma'am.
Okay, I'll talk to you then. I'll message you separately. Huh?
Okay, ma'am.
Okay.
Good evening, friends. Am I audible? Push, ma'am.
Yes, sir, you're audible.
Today is the 5th class of Mediation Education 2022, which is being attended by students from various parts of the country. The topic of today will be the process and stages of mediation. As a member of ENW and the mediation fraternity, it gives me immense pleasure to watch how the generation next has embraced mediation. Our wish is that students who attend this course go on to become professional mediators and mediation advocates. The students who are attending this course have shown commitment and seriousness in understanding the nuances of mediation. I congratulate all the students on spotting this chance and seizing it with both hands. We are fortunate to have a multifaceted personality as teacher mediator. Mr. Jawad AJ, an advocate practicing in the Madras High Court, has been an advocate for nearly 4 decades. He is a mediator, master trainer, a martial arts expert, and a philanthropist. Sri Jawad is a joint secretary of Tamil Nadu Mediation and Conciliation Center annexed to the Madras High Court and has been practicing mediation since 2008. He is part of ADR ODR International Faculty and is accredited as mediator by ADR Group UK since 2008. Along with few other leading lights of mediation, Mr. Jawad is a founder trustee of the Foundation for Comprehensive Dispute Resolution, FCDR, in Chennai, which is providing mediation services and training. Jawad sir is a teacher and a guide to almost all the mediators in India, including myself. Jawad sir has conducted training in National Judicial Academy, Bhopal, and several other state judicial academies. He is a visiting faculty with National Academy for Direct Access, Nagpur. He has trained most of us and is a much acclaimed trainer on mediation nationally and internationally. He is also training students for mediation programs and mediation tournaments all over the world. On behalf of ENW family and the students attending this program, I welcome Sri AJ Jawad to this program.
Thank you,
I
Shiraz.
urge the students to listen carefully to his words. To borrow the words of Thomas Hardy, I quote, "Gems of wisdom fall but once," unquote. E-Mediation Writings is a family of mediators which is doing yeoman service to the cause of mediation. Our journal, which is sui generis, is well regarded in the mediation fraternity both in India and abroad, particularly on account of the quality of articles carried by the journal. I welcome all members of the ENW family to today's class. ENW team is led by 2 efficient captains, one from the north and one from the south, Ms. Pushp Gupta and Mr. Tangachan. Both these dear friends have contributed their entire might for the ENW. I acknowledge and salute their efforts. I welcome all the students who are soul of today's class. Ms. Shaili Parashar, the 4th year LLB student from Jagran Lake City University, Bhopal, will be the student coordinator of this program. Over to Ms. Shaili. Thank you.
Thank you so much, sir. I welcome to everyone and good evening to all. I am Shelly Parashar from Jagran Lake City University. I'm in 4th year. Firstly, there are few rules in class. Please switch on, everyone please switch on their cameras so that class will be more interesting and interactive. Also, if you have any questions or queries about anything, so first raise your hand, then ask any question, sir. And please enjoy the class because I have attending all the sessions. They are very interesting and joyful because everything is new for us. Like even I have read the act and I know few things, but there are few things that we don't know about it, and it's a learning process. So yeah, please enjoy the class.
Thank you, Shaili. Over to Jawad, sir. So the floor is yours.
Thank you, Shaili. Thank you, Shiraz, for the very nice introduction. You're very kind. Thank you so much. Tangachan, I just want to check if I switch the gallery view on my computer, will it change it to gallery view for everyone or only for me?
I cannot see the figure. I cannot see.
Okay. No, I just wanted to. One sec. Yeah, I prefer to see everyone on the screen. That's
Okay,
fine.
okay.
I hope you don't mind. All right. So good evening, everyone. So welcome to this session. I'm told we've already been through 5 sessions. So I think many of you must be having a fair idea of what mediation is about. And today we are going to talk about how the process works. So before talking about how the process works, I just want to understand from you how do you understand the concept of mediation? How do you understand the concept of mediation?
Sir, shall I?
Yes, please.
Yes, yeah, sir. It's a process to like to resolve the conflict between the people. Am I mute?
Yeah, Shaili, I think you just got muted accidentally.
Yeah. Sir, now audible?
Yeah.
Yeah. So, sir, it's a process of resolving the conflict between the people so that everyone can resolve their issues easily. Like when we used to go to the courts, it's very like it's not too cost friendly and it take too much time to resolve the issues and other things. So we came up with the concept of mediation, arbitration, and other dispute resolving the processes methods that we use to get the easy justice access also, so that both the parties have their interest to settle the dispute, and everyone feel that yeah, I have get the justice.
Okay, that's very good. It's a good description of the concept of mediation, Shaili. But I just want to go a little beyond that. So, I mean, is it because one of the things you said was that to quickly, resolve the disputes. Is that the only thing that mediation does? If you compare it with arbitration and litigation and all that, of course, litigation takes a long time. And we all know that arbitration now, India is perhaps the only country in the world where the Arbitration Act prescribes a time limit for the completion of arbitrations. So if you look at it from that perspective, arbitration also is a very fast process, right? So why mediation? Why mediation? What is different about mediation from arbitration or litigation or anything else? Is it just
Hello, sir. Oh,
Yeah.
sorry.
Who's this?
Correct. Babli Misra.
Okay, Babli. Yeah, tell me.
So correct me if I'm wrong. So just in my point of view. So other than litigation, one party will be lose and one party will be win. But
Yeah.
in mediation, there will be a win-win process. So that's it. I just want to mention that one. Correct me if I'm wrong.
No, you're from a particular point of view. Yes, you're right in a sense, because both parties come out of it feeling that they have got something out of the process, and there's the concept of winning and losing is not there. But I would not say win-win, because when you say win, it's always the element of competition is there. So what am I winning? So what is the other person winning? If I win, how does the other person win? So there is a lot of anomaly surrounding that concept of win-win. I want to go a little beyond that. What differentiates mediation from other dispute resolution processes?
And maybe it is a collaborative way of resolving.
It is collaborative. Very good. Yes. Negotiation also is a collaborative way of resolving disputes. So why do you need, Kalpana, if you and I have a dispute, we can always sit across the table, talk to each other and resolve it. Why do we need a mediator for that?
Well, if we are interested to solve this between us, only then we can go for a negotiation. But where we really need a third person, there are chances where I may go back or you may go back.
Okay.
So we need a third person who can, resolve it.
Okay, that's good. But in mediation also, you can go back. You can withdraw from a mediation. It's a voluntary process.
Not exactly going back. There would be definitely a point of disagreement would definitely come, because we are on the edge of, where the disagreement may lead to dispute. We are on that edge. So it shouldn't elevate to that. Rather, it should get to a neutralized process.
Okay, I think you're very close to that. You're very close to what I'm trying to get out of you. Okay. So basically, from what I understand from you is that it is something where you want parties to go a little beyond where they are and see things from a different perspective. Is that what you're saying?
Yeah, positively.
Positively.
Correct. Because there is a point where we काम बनते बनते बिगड़ने की संभावना बहुत ज्यादा होती है.
Exactly. So in a negotiation, there is every possibility that we may not agree on certain things, and we will be looking at things only from our point of view, and therefore you need a neutral person who is going to help to balance both these views and take us forward. Yeah, that's very good. That's very good. That's closest that we have got so far. Anybody else?
Sir, I would like.
Yes, Shravanti, yes, please go ahead.
Yes, sir. Sir, I find mediation as a transformative process, and I also find it as I can call this as an amicable dispute resolution method.
Okay.
Yes, it's more of a place where the mediator doesn't really speak much, or it's more of a suggestive procedure. Okay. And trying to get the parties resolve it within themselves, actually.
Exactly. Yeah, very good. So basically, the whole idea is to help the parties to find their own solutions. So where the mediator plays a sort of not a too proactive a role, but a role where the mediator guides them towards that solution, right? Where they are able to look at the dispute from a different perspective and perhaps come to some conclusion. Okay, that's also very good. Yes, Yasmin B.
Sir, good evening, sir. Yes,
good
evening. Sir, maybe mediation cannot solve the dispute, but the process can clarify the parties, like actually what is the issue, what they want. Maybe they have some confusion, so maybe they can help out the main reason of the dispute, so that they can amicably solve between them. Because the third party is anyhow neutral. He don't have any interest in any one of the party. So you can make them clear at least like what they have to actually.
Okay, I think
sometimes the issue will be very small. But
yeah, I think what you have pointed out is that there is something more than what is visible, because there is something which is underlying a dispute, and perhaps mediation helps parties to explore that and then see what is best for them. Very good, beautiful. Tanishka?
Yes, sir. Am I audible?
Yes, you are audible, Tanishka. What happened to your video?
It won't be possible for me to on.
Okay, doesn't matter. No problem. Go ahead.
Good evening, sir.
Good evening.
So my point was that in mediation, one more good thing is there. It's of the things are confidential also between the parties, between the mediator and client. It's a very good thing because things are not confidential in courts.
Yes.
But in mediation, there are single sessions, there are joint sessions, so parties be free.
Yeah.
In front of the mediator also.
Okay, so you promise the parties that it is a confidential process, that whatever we discuss is not going to go outside the room, and nobody else is going to know what we are talking about.
Yeah.
So it gives them an element of comfort and puts them at a place where they are able to, discuss things that are really important for them, correct? Yeah.
Yes, sir. Yes.
Yeah, very good, Tanishka. Okay, now I just want to put a few points before you. I want to tell you how I look at mediation, and I want you to tell me whether I'm right or wrong. Okay. Now, whether you take litigation, whether you take arbitration, basically what we do is we have a set of rules, which we call as laws, which say that what is your right and what is right, what is wrong, right? And what happens in litigation or arbitration is when you have a dispute, when you go to the court or when you go for arbitration, those rules are applied to the facts in dispute, and a formula, that is how that law should be interpreted, how the facts should fit into the law, whether the what will be applicable to the facts of the given case. So the deciding authority, the adjudicator, either a judge or an arbitrator, then tells the parties that, look, you are wrong. Okay. Jawad, you are wrong. Kalpana is right. So Kalpana is entitled to claim this from you. Therefore, we declare that you should pay Kalpana so much, or you should do this for Kalpana, or you should hand over this property to Kalpana, whatever the judgment might be, right? Now, in this process, what happens is between Kalpana and me, there might be many things. Okay. If let's say that we are brother and sister, for example, and our parents are no more and they have left behind some property and we are fighting over the property. Now, a lot of things would have happened between us. Okay, we would have got angry with each other, we would have abused each other, we would have shouted at each other, and we will be very hurt with each other, correct? Now, the arbitrator or the judge is not concerned about all these things. Okay, the arbitrator or the judge is going to see a few simple things. It's going to see what are the properties that are available, what kind of law is applicable to the parties. Are they Muslims? Are they Christians? Are they Hindus? Are they Parsis? Whatever. Okay. Under that law, how much is Kalpana entitled to? How much is Jawad entitled to? Now, is this property capable of being divided and given to both of them? Okay. Now, for all you know, that Kalpana and I may not really want a partition. It is just that a misunderstanding has developed between us and we are fighting about it. And we have reached a stage where we start calling names and we start abusing each other. But the judge or the arbitrator is not concerned about that. Okay. Whereas in mediation, it becomes very important as to what Kalpana feels about this, what Jawad feels about this dispute. Okay. So a mediator goes beyond the facts that are presented to him or her and looks at what is who are these people who are involved in this dispute? Where do they come from? How do they feel about this? What is driving this conflict? What has actually triggered this fight between them? How are they feeling about that? What are their real interests? Is it only partition of property, or is it the way the relationship has worked out? Is it something more than just the facts that are presented before me? So mediator goes beyond that and explores those possibilities. And helps the parties to see that, okay, this is where you stand today. Okay, this is how you're looking at the dispute. But see if there is a different way of looking at it. See if you can look at it from a different point of view. Or perhaps look at it from each other's point of view and try to understand what is driving this. Okay, why are you here? What can you do about this? How can you resolve this? How can you get back on track with each other? How can your relationship be mended? Is there a possibility that your relationship can get back on track, along with whatever needs to be done about the property? So mediator goes beyond that. So the purpose of mediation is not just to help parties to reach an agreement. Not just to reach a settlement. Many times you may be able only to reach a settlement. I'm not saying that, but the objective of mediation is to find a resolution which goes beyond the settlement. So which means that if tomorrow Kalpana and I meet and talk to each other, we should be able to meet eye to eye and talk to each other. I should be able to invite Kalpana to my house. I should be able to go to Kalpana's house. Our children should be able to meet each other, okay, talk to each other. So that is what in mediation we try. We aim at resolving the conflict, not merely settling the dispute. I'm not saying every mediation ends in resolution of the conflict. Okay, it happens that you try for it, but ultimately it's in the parties' hands, because all of you agree that ultimately parties decide how they want to resolve the dispute, right? So they may be happy with the settlement. So if Jawad and Kalpana feel that, okay, let's just divide this property and be happy with it and go along with it. Let's not get back into our relationship. I don't care what happens to my sister. My sister doesn't care what happens to me. So we'll go our own ways, and perhaps over a period of time, we may, start seeing, each other, and maybe our relationship may get back on track. But for now, we don't want to do anything with each other. We just want this property to be divided. It's possible, no doubt about it. But in a mediation, what happens is, because of what the mediator does with the parties, the way the mediator works with the parties, it sets them on that journey. It helps them to start that journey. It helps them to think, am I right? Am I right in thinking this way?
Yes.
Am I doing
Yes,
the right
sir.
Yes, sir.
Yeah?
It in the future relationships also, not unlike like in courts disputes.
Yes. So in the court, we are not bothered about what happens to the relationship. We are bothered about only what relief we can give them, like in the sense that the substantive relief. Now, the mediation process, how should it be structured? See, if you go to the court or if you go for arbitration, one, the process is very clear. The procedure is very clear. The procedure that you follow, we have the Civil Procedure Code, we have the Arbitration and Conciliation Act. In arbitration, you have also the freedom to agree upon a procedure. Okay, if you don't agree, the Arbitration Conciliation Act procedure applies. Okay, you can agree on who should be your arbitrator. So you have much more flexibility in arbitration. In litigation, you don't have that flexibility. You cannot choose your procedure because the Civil Procedure Code already tells you that this is how you should apply. So you have that procedural satisfaction that, yes, this is how we should proceed. Okay, and in this process, this is what is going to happen. You know that very well, right? Substantive satisfaction. What do I get out of that litigation or arbitration? In that, as I think, who was it? Shaili pointed out, or I think Shaili said that. Okay, so I may win and Kalpana may lose, or Kalpana may win, I may lose. So Kalpana may get, if she wins, she may get that substantive satisfaction that, yes, I got what I wanted. And I'm not going to be very happy about it because I did not get what I wanted. Okay. So what happens after that is I challenge that. I go and appeal. Whether it is arbitration or litigation, there is always a dissatisfaction on the part of one party, but sometimes it might be both parties also. Kalpana also may not be happy about what she has got out of it. Isn't it possible? Because if the court decides, if the court passes the judgment, Kalpana may not get exactly what she wanted. Right? I have already lost. So I have not got what I wanted at all. Now Kalpana has got something, but not exactly what she wanted. So she's also not happy about it. Okay. So the substantive satisfaction may not be there. But one thing definitely that is not there is the emotional satisfaction.
Yes, so
Because we are all humans, right? We are human beings, okay? We are feeling, thinking human beings. We are not just plaintiffs and defendants. So what the law does is it takes away your personality, it takes away your identity and makes you a plaintiff or a defendant or a petitioner or a respondent or a complainant and an accused. But in mediation, your identity remains intact. You are who you are. Kalpana is who she is. And it matters about what Kalpana thinks and feels about this. Okay, it matters what I think and feel about this. Okay, so in mediation, we give a lot of importance to what people think and feel about the dispute, about the conflict. We don't brush that under the carpet. We don't tell them that, look, we are not bothered about what you're thinking or feeling. We say it's very important to us. We would like to hear what you're thinking about this. We would like to hear what you're feeling about this. We would like to understand you better. We would like to know you better. So the human element, you know, that human element that we recognize human beings for who they are, as thinking, conscious, feeling, sentient beings who can think and feel and, you know, who are emotional, who can get angry, who can get sad, who can feel happy, who can feel joyous, who can jump with joy, who can cry with sorrow. We recognize this. So, friends, I just want you to keep this very important facet in mind of mediation. Because mediation is all about people. It's all about who they are. They are the most important there. You walk into a lawyer's office, you lose your identity. Okay, after that, it's the lawyer's job. The only chance you get to open your mouth, perhaps, if there is the trial, you get into the witness box and you speak. And there also, you're severely curtailed. Nobody wants to hear what you feel about this. It's all about facts, it's all about the law. Okay, so you're PW1 or DW2 or whatever you might be. You're a plaintiff, you're a defendant. That's it. You're not Kalpana, you're not Shaili, you're not Tangachan, you're not bubbly. Okay. You lose that identity. But in mediation, please understand that it's all about people. Okay, this might have sounded like a sermon to all of you. Okay, I'm sorry about that. But in order to understand the process of mediation, I think we need to understand this conceptual framework of mediation. How mediation differs from all other dispute resolution processes. Okay, how mediation differs is simply this: it treats human beings as human beings. It treats people as people. It understands that people have feelings, people have emotions. People get angry, they can be unreasonable. Okay? They can be stupid. I mean, I have a right to be stupid if I want to, right? Who can question me on that? Right? So this is the most important aspect of mediation. Do we all agree on that?
Yes, sir.
Yes, sir.
We think because in every relationship there is a hope, like hope of having a better relationship with that same person.
Exactly.
So
Yeah.
surely.
Exactly, because sometimes we are so angry that we want to hate each other, we want to hurt each other. But ultimately, deep down, see, basically, let's understand how we have evolved as human beings, okay? See, we started off as hunters and gatherers. For 95% of our existence on this planet Earth, we have been hunters and gatherers. Do you know that our civilization is only 5% of the time that we have existed on this earth? It's only 10,000 years old. But we have existed for thousands of years before that. And we were hunters and gatherers. Okay, there, what used to happen was, see, a very interesting finding that anthropologists came across was, there was a controversy as to how Homo sapiens, the species Homo sapiens, we are Homo sapiens, right? We all agree we are Homo sapiens here. No other species is here, right? So, okay, I'm also Homo sapiens. Sometimes I have to ask my wife and get that confirmation. So, anyway, we are all Homo sapiens. Now, how did we survive? So one theory was that basically we are very selfish, okay? And it's always the survival of the fittest. So we have trampled over other species and we have asserted ourselves and we have survived. But anthropologists made some very important discoveries. They found that, there was another species of humans that was coexisting with us several thousand years back. They were the Neanderthals. Have you heard of Neanderthals? Yeah, Neanderthals.
Yes, sir.
Okay, they had bigger brains than us. They were much stronger than us, more muscular, bigger in size, everything, okay? They were more well-developed than us. But that species became extinct, whereas human beings survived. Okay, and today we control the universe. Okay, we control every facet of life. We control every other species on this earth. And if we are stupid enough, we'll very soon be going extinct ourselves along with all the other species. If we are intelligent enough, we'll be saving this earth. Okay. So, but the fact is, how did we survive? Were we selfish? Anthropologists found that when they, when they discovered the bones of Neanderthals, they found that a bone that is fractured was fractured. I mean, it was broken. It did not heal. Whereas in Homo sapiens, they found that the bones have healed. Imagine when you are hunters and gatherers, it means that when one of us got injured or broke a leg, the others stayed back, looked after the injured person, waited until that person recovered and then moved on. Whereas the Neanderthals did not do that. They used to go away, leaving this person to die. So that's how they found that the Homo sapiens bones had healed, whereas the Neanderthals bones were not healed. They remained broken because they were abandoned by their own species. Now, this is what is called as empathy. Okay. So human beings are basically hardwired for empathy. But why do we fight? Why do we divide ourselves? It's because of the tribalism. We are also, tribalism is intrinsic to us. We are hardwired for tribalism. We like to be with people who are like us, who think like us, who dress like us, who eat like us, who believe like us. So that is how we divide ourselves. But actually, we are hardwired for empathy. If we come out of the tribal mindset, we are very kind people. Okay, we like to help each other. We don't want to fight. Who likes to be in conflict? Tell me here. In this group here, tell me who would like to be in a fight? Would you like to, supposing, because many of you are students here, I want to ask you one question. If you have a fight with, let's say, your parents or your siblings, do you feel happy about it?
No, sir.
You don't,
No, sir.
right?
No, sir.
You lose your sleep. You become, very upset. You're angry. Okay. You feel like breaking things. Basically, you're unhappy. Okay.
Yes, sir.
So the moment a patch up happens, when you get back into a good relationship, you feel peace of mind. So nobody wants conflict. Okay, nobody likes to thrive and nobody thrives in conflict. There are a few people. Okay, there are some, there is a writer called Bill Eddy. I had the occasion to meet him in Dubai. Okay, he has written about high conflict personalities. Okay, he talks about certain people who thrive in conflict, who love to live in conflict. Okay, I'm not talking about those. I'm talking about normal human beings like us. Sometimes we have to look at ourselves and see, are we high conflict personalities? Do we love to fight? Okay, we have to keep checking ourselves. Okay. So anyway, coming back. Now, why I wanted to talk to you about this before going into the process is, unless we understand the concept of mediation in its true sense, we won't understand why the process is important in mediation. Okay. So process is very important in mediation simply for the reason that we are, as mediators, we are intervening in people's lives and we are helping them to resolve their conflicts. Now tell me, if I, as an utter stranger, come and sit and talk to you and ask you, Yasmin, what do you feel about this? What is happening with you? Would you like to answer me? You might say, who the hell are you? Why should I talk to you?
Yes, yes.
Right? You may not like to talk to me. Okay, so it is audacious on my part to go and sit in some place and ask somebody, tell me about yourself. Okay? How do I do that? It's not easy. You're in conflict. Okay, you're angry. You're emotional. And here is somebody who comes there and says, talk to me. Oh, I don't feel like talking, get lost. That might be a response, right? Now, how do I get to that place where you're able to talk to me and tell me your deepest secrets? How do you disclose to me that information that you yourself may not have been aware of? How do I go into the depths of your personality and understand who you are? And help you to understand who you are? I'm not talking about psychotherapy here. Okay? I'm talking about mediation. I'm talking about resolving disputes. Now, how do I do that? So that is why a process has been evolved for that. Okay, how do we get to that place where we develop the trust and confidence in the parties' minds? Okay, I have made it a little bit, sound a little bit too romantic, I suppose. So, okay, I want to whittle that down a bit. It always doesn't, you may not succeed always in achieving that objective, but there's no harm in trying. That's what I'm trying to say. But what is important for us is to understand what our role is as mediators. Okay, so that becomes very important. So how do we do that? How do we reach that space in the lives of people where they're able to talk to us, tell us their fears, tell us what they feel about it, okay, allow us to probe in their minds and think, help them to think differently. How do we reach that space? How do we reach that point where we are able to talk to them? Now, that is the challenge of the mediator, and that is why the process is designed to help the mediator to achieve that objective. So the first and foremost is, I'm not going into the other, procedural aspects like convening a mediation. For example, in a private mediation, I'm not talking about court annex mediation where the court refers disputes to you and you sit there and you talk to the parties. I'm talking about where you as a professional mediator are directly approached by the parties. Because they know that, okay, Shiraz is a very well-known mediator, so therefore let me go and talk to him and find out what he can do about this. So I go to Shiraz. Now, I'm talking about that. So what Shiraz does is first discusses with me and first invites the other party also, saying that, look, Jawad has approached me. So would you like me to mediate your dispute? And if the other person says yes, then Shiraz talks to both of us and first agrees that, okay, we would like to appoint you as a mediator and we would like you to help us to resolve our dispute. So he gets into that. First, he gets us to agree to that and agree to how the process is going to be conducted, what his role is going to be, all that. Of course, the fees, very important point, right? Fees are important, right? We need to earn money also. So we need to earn a livelihood out of mediation. So nothing wrong with that. Okay, so we talk about that. Okay, so once we reach an agreement on that, the mediation starts. Okay. So both parties are coming to Shiraz. And how do you think Shiraz should start the mediation? How do you think he should start?
Like introducing himself.
Give them a right environment.
By
Introducing himself, yes. Mohit, you said something?
Yes, sir. Give them a right environment.
Create the right environment. Okay. Yeah.
Homely.
Homely. Okay. Very good. Okay. So
Not-
you make
not
them
going
feel
directly
comfortable
to
first.
it.
You introduce yourself. You find out how they would like to be addressed. I normally make it a point to tell them that, I would like to be called as Jawad. Okay. And I ask them, how would you like to be addressed? Because there is an air of informality that I want to establish there. I don't want it to be a too formal proceeding. Okay. I don't want them to think that they are with some lawyer or with some judge or somebody like that. So I tell them that, okay, please call me Jawad, because I want them to feel that I'm their friend. Okay. So one of the best ways to do that is to tell them that you can call me by my first name.
Yeah.
Okay. So that is the best way to reach out to people. Okay.
Yes.
So when you have that sir and that all that other formalities, there's always the distance that you have. Okay. So first you put them at ease by telling them that please call me by my first name and tell me how you would like to be addressed, because that's very important. You have to be polite. So once they tell you that, okay, we would like to be addressed as so-and-so. Okay, I would like to be called as Kalpana. I would like to be called as Shaili or Mohit or whatever. So once I establish that, then I ask them, okay, now we are going to be discussing about the issues that are there between the two of you. Now I want to understand, do you have the authority to decide for yourself? Because what happens in many conflicts, many disputes is there's somebody else who's pulling the strings from behind. If it is a commercial dispute, there might be a CEO who's not there before you. If it's a family dispute, there might be a father-in-law or a mother-in-law who's not there before you. Okay. If it's a partition dispute, there might be a spouse who's not there before you and who might be calling the shots. So we don't know. So we have to first ascertain, do you have the authority to decide? Shaili, you have a question?
Yes, sir. Sir, like we have an arbitration, a prior agreement before the dispute. So in the process of mediation, do we have the agreement when I come to you for the process of the mediation? So do we have an agreement between us as a party?
That's a very important question, Shaili. The thing is, the difference between arbitration and mediation is, under the Arbitration Act, unless there is an agreement in writing, you cannot go for arbitration. You cannot invoke arbitration. And once there is an agreement in writing, arbitration is mandatory, like it becomes binding. So even if the other party ignores the arbitration clause and goes to the court, I can always go to the court and tell the court that, look, there is an arbitration clause. Please stay the suit and send us to arbitration. I can do that. In mediation, that requirement is not there. I don't have to have an agreement. But many contracts today include a mediation clause. They say that first we'll explore mediation. If it doesn't work out, we'll go for arbitration. Okay, that possibility is there. That can always be done. But it is not mandatory that I should have an agreement to go for mediation. I can always agree with the other party. Okay, now, for example, we have part 3 of the Arbitration Conciliation Act, which talks about conciliation, where if I have a dispute, I can approach somebody and ask the person to be a conciliator, or I can issue a notice to the other side and tell them that, look, I want this dispute to be conciliated. Therefore, please indicate your consent for this. Now, it's a different matter if the law declares mediation as mandatory. Like, for example, 12A of the Commercial Courts Act is there. It says that before you come to the court, you have to try mediation. Now, when the Mediation Act comes into force, it is going to mandate mediation. It's going to say that at least 2 sessions of mediation, only then you can come to the court. Now, there you go for mediation because the law mandates it. Okay, but you don't need to have an agreement like how you need to compulsorily have an agreement in arbitration. Because without an agreement, written agreement, you cannot go for arbitration. Whereas for mediation, it can even be an oral understanding that, okay, let's mediate this. Okay. So once you do, coming back to the process, So once we have that, sorry, I'm not using PowerPoints. Okay, I don't like to generally use PowerPoints, but I just want you to listen carefully and make your notes. Okay, so any point of time you have any confusion, please stop me and ask me questions. Okay, and if you're feeling bored, don't doze off. Okay, put off your cameras and doze off. Just tell me, boss, you sound very boring. Please change tack. Okay, I'll be happy to change it. Okay, and please feel free to interrupt me and ask questions also. Okay, so what we do is we ask them for the authority, whether you have the authority to decide, because that becomes very important, you know. Because what happens, you do the whole process. Because you know, in one mediation, what happened was it was a court-referred mediation, and it was between two companies. It was regarding the construction of a port, a particular construction in the port. Now, what happened in this mediation was this man who was the general manager of that company was participating. He had the authorization also. He had a board resolution authorizing. But when we were about to reach an agreement, he said, "Sir, I have to get back to my MD. MD only has to decide." So we were back to square one because MD did not go through the process with us. So he doesn't know what actually happened here. And we don't know to what extent this man has been able to convey the day-to-day developments or the proceedings that were happening. So it becomes very important, because I always make it a point to ascertain from them, do you have the authority to decide, or do you have to get back to somebody and get their confirmation? Now, if that is there, I would like that person to be present here. And if the deciding authority, or the person who has the authority to take decisions, is not before me, I would not like to do the mediation, because it is pointless. Because that person is not there to experience the process. He doesn't go, or she doesn't go through that process of mediation to understand why exactly we are reaching this particular agreement. Okay, so therefore I take the precaution of asking them, do you have the authority to decide? Now, once I confirm that there's nobody else and these people have the authority to decide, I tell them that, look, let me explain to you what the process of mediation is. Now, that's called the mediator's opening statement. Now, this opening statement is a very, very crucial part of the mediation process. Because in my opening statement, I'm going to tell them how the process of mediation works, what are its attributes, what is my role in it, what is their role in it, okay, and what they can expect out of this process, and what are the rules that they need to follow. This is the broad framework of an opening statement. But how I do it is, I don't do it mechanically. Now, if you fly, once you sit in the aircraft, the steward or the stewardess will make their opening statement, right? They will inform you about the safety regulations. Most of the time, they don't even look at you. Mechanically, they'll be reciting something. You might be browsing through your magazine, or you might be looking out of the window, or you might be talking to your friend or whoever is sitting next to you. Okay, but they're not bothered. But their job is to deliver that safety instruction to you. Whether you listen to it or not, it's your problem. They're not bothered about it. But an opening statement is not like that. It's not mechanical. But that is an opportunity for the mediator to develop the connection with the parties, to put them at ease, to help them to understand that they are in control of this whole thing. Okay, what is your role? What are you going to be doing with them? So it's an opportunity for you to build the trust and the connection with the parties. So when I make an opening statement, I don't do it mechanically. When I'm saying I do, that means that when you do the opening statement also, it should not be done mechanically. Okay, it should be very friendly. Okay, you should smile. You should look at both the parties. Keep eye contact with both parties so that one party doesn't feel that you're talking to only one. Because sometimes we have this tendency. If the party who has smiled at us while entering the room, we tend to focus only on that party. And the other party who had a very stern expression on her face or his face, we may not look at that person. It's human nature. But you have to be conscious about that. Okay, you have to be conscious and look at both parties. So what I tell them is, look, we are here in your mediation. Okay, this is your process. Okay, I'm not a judge. I'm not going to be deciding this dispute. I'm going to be only facilitating this conversation between the two of you to see how we can resolve the issues that are there between the two of you. And I'm very careful not to use any negative words. I don't say conflict, I don't say dispute. I use a very neutral word like, what are the issues between you? I'm here to help you to resolve that. I'm here to help you to have that conversation to see how you can resolve it. So I'm only a facilitator. And I tell them that, look, this is a voluntary process. You're free to walk out of it anytime you want. It's not binding on you to take part in this process. And if you walk out of this, you're back to square one, where you started from. So it is also without prejudice. So nothing's going to harm you. You're not going to suffer any loss because of taking part in the mediation process. So I have told them it is voluntary. I have told them it is without prejudice. Now I also tell them that it is confidential. Now when I tell them it is voluntary and I tell them that they can walk out, I also tell them, but I would urge you not to take that decision in a hurry, to walk out of the process. Because today you're in a seat of power. You have control over your problem. And you can find the solution for that. If you walk out of this, it is going to go in somebody else's hands. Okay, so today you are in that seat of power. I had this once, a tenant who barged into the mediation room and looked at me and said that, who are you? See, he was referred by the court. Okay, he was very angry that he was referred to mediation. So he barges into the room, looks at me, points his finger at me very angrily. He says, who are you? Why should I sit and talk to you? Why should I listen to you? I smiled at him and I said, would you mind sitting down for a minute? He sat down reluctantly. I told him that, okay, before you came here, who had the power to decide this dispute? He said, the judge. I said, well, this is what the judge has done. He has taken that power and given it to you. And he says, use this power to find a solution to your problem. And here is a person who's going to help you to do that. Now you have to use the power to see how you can find a solution. Just as your counterparty is going to be doing the same thing. Now, if you don't want to use this power, you can always go to the court and tell the court, I'm sorry, sir, take back this. You use it. I don't want to use it. It's your choice. So therefore, I don't need power because you have the power. So why should I need the power? He relaxed and he sat down and we went ahead with the mediation. Okay, so I tell them that you're in a seat of power today. Okay, so you have the responsibility of taking your own decisions. You have the power to take your own decisions. So I tell them that don't walk away so easily unless we are not able to reach anything at all. And I tell them that I'm not going to give up easily. Okay, and I'm going to sit with you and I'm going to work with you until we are able to resolve this. So I give them that assurance. Then I tell them it's confidential. Whatever we are going to be talking here is completely confidential. Nothing of this is going to go back anywhere else. I am bound by confidentiality. You're bound by confidentiality. So we both agree that it is confidential. And it's of two levels. One is the confidentiality between us vis-a-vis the outside world. The other level of confidentiality is in the course of this, I may be talking to each one of you separately. So those are called private sessions. And when we have those private sessions, any information that you disclose to me, I'll keep it confidential. Without your permission, I will not disclose it to the other person. I assure them about that. And I make that promise to them. Okay. And then I tell them that, look, this is a very informal process. Okay. That's why I told you, you can call me by my first name. And thank you for allowing me to call you by your first names. But there are two simple housekeeping rules that we need to follow. And because we are here, sitting here to amicably resolve this problem, we can't do anything if we keep interrupting each other. So rule number one is we don't interrupt each other. You may not like what the other person is saying. Wait patiently. When your turn comes, you speak. Make a note of what you have to say. Number two is, because we are here to find an amicable resolution of your issues, let us be polite with each other. Let's be civilized with each other. Let's not use any strong words or words that might hurt each other, because that is going to only aggravate the problem, not solve it. So once I help them to understand this, then I tell them that now I would like to listen to both of you. Okay, so I always start with the requesting party, whoever has requested for the mediation, because that makes it easy. So I tell them that, okay, I would like to hear from you what you think about this and where you stand today. So I listen. So the next stage is, this is my opening statement. Okay, so this is the first stage of the mediation. Now I'm going to the second stage. Now the second stage is a very crucial stage. Very, very critical stage. Okay, it is called the information gathering stage. It's called the information gathering stage. We also call it as getting the whole story stage. I'm sure people would have spoken to you about active listening, communication skills and all that. Have you been through that? Yeah, you know what is active listening, right?
Yes.
Can anyone tell me what is active listening?
At now present, what we are doing, sir, listening to you actively.
Wonderful.
Sir, basically it is listening
And
to someone.
it's also very reassuring, Yasmin. Thank you. I'm glad you're listening actively. Who was saying something?
Myself, sir. It's actually listening to someone without prompting or asking any question or giving any suggestions for that period of time.
No, does it mean that you don't ask any questions at all? Active
No.
listening.
I mean, not giving any suggestions as such, or not prompting too often.
Yeah, you see, you don't interrupt too often, but sometimes you may have to ask for clarifications.
Yes.
You may have to reframe what the person is saying. Like, for example, if somebody is saying that, my partner is a crook, he's a cheat, and he suppresses information from the customers, and this leads to a bad name. Now, these are all a lot of very toxic words that are coming out, and the other person is listening. So I have to reframe that, and I have to put it in the right perspective. Yes, sir, you want to ask some questions?
Okay, say attentive listening.
Attentive listening. Yeah, you listen attentively. You also listen actively, because when you're listening actively, see, now when I see you on the screen, I can see many of you nodding your head, right?
That's right.
Now, because you're muted, I'm not able to hear you saying, oh, okay, oh, I see, okay, I'm not able to listen to that. Those are called extenders. But when face to face with somebody, when I'm listening, I have to show them that I'm listening. Okay? Oh, I see. Oh, okay. Oh, okay. So I keep responding. Okay, I show them that I'm listening. I keep nodding my head. Okay.
That's right.
Now, whenever something very toxic comes out, I try to reframe that. Okay. I say that, okay, what I hear from you now is that you want the business to run in a very honest and transparent manner. So what I'm doing now, when I say that, when I reframe, is I'm removing the toxicity. Cheat, crook, dishonest, suppression, all that I'm removing. And I'm saying that if you have already been spoken about separating the people from the problem, you will understand that. Okay, so what I'm doing in reframing is, I'm pointing out to both of them that, okay, here the problem is not each other. It's not that this person is accusing this person of something, or this person is being accused of something. It's that this person wants the business to be run in a particular way. So I'm moving them also to the future. Okay, so what needs to be done? I'm focusing their attention on that. I'm taking their mind off the negativity of the whole thing. The negative perception of each other, I'm moving that and putting it in a very positive frame. Okay, so that is essentially reframing. So it is an integral part of active listening. So sometimes when I'm listening to people, I have to do that reframing occasionally. Okay, because I don't want them to, start, oh, how dare he call me a crook? He's the crook. Immediately that response will come. So before that response comes, I quickly intervene and I say that, okay, what I hear from you is you want the business to be done in an honest and transparent manner. And you're very disappointed that it is not being done so. Okay. So I'm shifting, I'm removing the person and I'm focusing on the problem. Okay. So this reframing becomes essential. So when I'm gathering this information, I'm asking them clarifications. Okay. Can you explain this to me a little more? Can you help me to understand this better? I'm a little confused about the dates. Can you just clarify the dates a bit? Now, I make sure that I'm listening to everything. Okay. And at the end of that, I summarize. Now, in the process, I'm also empathizing. Okay, if somebody is very upset about something, I can see that this has upset you. So I label that. I can see that you're very angry about the situation. So I label that emotion. I recognize that, okay, you're feeling angry, I recognize it. I may not agree with that. That is empathy, right? I may not agree with that, but I recognize how you feel about this. I see how you feel about this. So this is the information gathering stage. Okay, now what I do is, I am not satisfied with understanding just the facts of the case, just the facts of the dispute. I'm going beyond that. Now, what I do in this information gathering stage is, sometimes there might be certain things that parties may like to tell me privately, which they may not like the other person to know. Now, many mediators get confused between stages of mediation. They say that you have the opening statement, you have the joint session, you have the private session. Joint sessions and private sessions are tools that you use in a mediation, like how you use active listening, how you use empathy, how you use reframing. Okay, all these things are tools and techniques that you use in a mediation to get the information from the parties. Because sometimes they may not like to discuss certain things in the presence of the other party. Either they may feel intimidated or they may feel that the other party may take advantage of something. So they may not like to discuss. So what I do is I have this in joint and private sessions. So first I listen to them in the joint session. Then I tell them, okay, I feel now that, it is time for us to have some private sessions. So here's what I'm going to do. I'm going to go into a private session with so-and-so. Now, what I do here is I always choose the person whom I heard second. Because when I start the joint session, I would have started with party A. Let's say party A is the requesting party or the plaintiff or whoever. I start with this person. Now, I want to maintain the balance. So what I do is in the private session, I say that because I started with you, I'm going to start the private session with B. I started with A, now I'm going to start with B. I go into the private session and I do the same. So what I do in this process is, I don't just listen to the facts. I listen to also what they feel about it. Okay. And my questions are open-ended questions, which are designed to give them, to encourage them to come up with more information. Now, all the time I'm smiling at them. I'm listening attentively. I'm showing them that I'm their friend. Okay. And I'm interested in their welfare. And I'm here to help them. Now, what happens in this is they develop that trust in me. Friends, I want to share with you one experience which I had, which was a very moving experience for me personally. There was this case I was mediating between, it was a custody dispute, okay? And this lady had to run away to Punjab, leaving her 8-month-old child with the husband. She had to run away because of the ill treatment meted out to her. Now she came back, she claimed the custody of the child. And when we were having a private session, her lady advocate was there. She asked the lady advocate to step out of the room. She said, I want to discuss something with you. And with me, an utter stranger, a man, she sat and discussed some very intimate details about her life with her husband. Now, imagine the kind of trust that she would have developed for her to be able to discuss that. Okay. Now, this is what the kind of trust that we develop with the parties, because they have to trust you. Okay. And unless you show them, see, this is what is called as a strategic trust. Okay. There are two kinds of trust. One is emotional trust. I trust my wife, I trust my son, I trust my daughter, I trust my brother, I trust my friend. When I trust a lawyer, when I trust a doctor, it is a strategic trust. Now, the first trust which I have based on a relationship is emotional trust. Because this is my father, because this is my wife, because this is my husband, or because this is my brother, because this is my sister, I trust them. When I trust a professional, when I trust a mediator, when I trust a lawyer, it's because of your professional knowledge, your expertise in that, right? So when you show that you know what you're doing, when you establish that trust, they develop their strategic trust in you. So this session, the information gathering session, the storytelling session, is very, very important, because this can last for a long time. There's no time limit on this. And you should never be in a hurry to finish this fast. Now, I repeat this several times. Sometimes I tell the parties that, okay, and always summarize. Once they have spoken, summarize to show that you have understood. Summarize doesn't mean you repeat the whole thing. But what are the crucial things? Include the facts and the feelings in your summary. So this is what happened to you. And you are upset about this. And have I understood you correctly? So summarize that. Okay, facts and feelings. So once you summarize that, tell them that, okay, I'm going to go to the other party and talk to them. In the meantime, I want you to think, is there anything more that you would like to discuss with me? Is there something that you have left out? Is there any more information that you need to share with me? I go up to the other party. I do the same exercise with that party. Okay, so joint and private sessions. First, I start with the joint session. I take it to the private session and I repeat the private session each time. So now what I do when I exit this information gathering stage, I should be fully equipped with all the information. The factual information, the emotional information. I should be aware of what is driving this conflict. What are the underlying interests of the parties? I should be very clear with that. Now I'm very clear with what the issues are. Okay. And I distill these issues with the parties. I try to understand from them whether we are on the same page. So I tell you, Kalpana, have I understood you correctly? Now, according to what I understand from you, these are the important issues. Correct me if I'm wrong. And then Kalpana has the opportunity to tell me that, Jawad, I think you left out this point. Okay, this is also important for me. So when I summarize, I ask her, can you tell me this? Okay, am I right in understanding that these are the important things that we need to be working on now? And this is what we need to be discussing. So those issues are very important. Okay. Shaili, you want to ask something? I see
yes.
a lot of questions in the chat. I'm sorry, I'm not able to see all those questions, but perhaps we can ask them at the end of the session. Okay. Yeah.
Sir, so when you as a moderator moderating between the parties, so there is, for instance, party A who asked you to not disclose some information which is very important to like resolve the dispute and to get the solution.
Yes.
So in that case, you as a moderator, what are the steps you take and how you convince the party that no, this can't be a confidential information. This information need to be discussed between the parties. So like your experience.
Very, very good question, Shaili. I'm so glad you asked this question. Okay. See, here's the point. Confidential information is confidential information. Under no circumstances you can breach the confidentiality. But as you rightly said, supposing I feel that, this information, if it comes to the knowledge of the other person, this might help us to move forward. Now, what I do is I sit with you. I ask you, Shaili, you have told me this and you have asked me to keep it confidential. Okay. Now I want to ask you something. Now, if I take this information to Kalpana, do you think this will help Kalpana to get the right picture of what has actually happened? Do you think it will help Kalpana to move forward? Now, if Shaili, you permit me, I take the information. Now, if you don't permit me, I don't take the information. No matter what the consequence of that. Please understand one thing. You own the problem, you own the information, and you have every right to decide what you want to do with that information. Right? I can only ask you that, okay, this may help us to move forward. Would you like me to share this information or would you like me to keep it confidential? Please understand, I'm bound by the confidentiality. I cannot disclose it without your permission. But if you permit me, I can discuss this with the other person. Now, when you're asking this permission, also make sure that that information is not going to prejudice. For example, if Shaili, you're telling me some information and I feel I should take this to Kalpana, I have to be sure that it is not going to prejudice you or hurt you in any way. Kalpana should not take advantage of this information to take a very strong stand against you or gain an advantage over you. So I have to be very careful there. Okay. So I normally respect confidentiality. Okay. Now, if it is very important, I ask your permission. If you give me the permission, I don't take that information immediately. I first check with Kalpana whether she has already got some understanding about this. Kalpana, can you tell me something more about this? Can you explain to me what actually happened? Okay. Do you think something could have happened like this? So I check with you whether you already know that information before I disclose it, because I still don't know how it is going to prejudice Shaili. So I'm very careful there. Okay. So be very careful about sharing confidential information. Unless it's absolutely important, don't do it. Right? Good. So now, when I finish this information gathering stage, I have a clear picture of where the parties stand. Okay. What is the factual background of this whole dispute? How they feel about it? What is important for them? Okay. What are the main issues that need to be discussed and addressed? Now, in this process, I also challenge their perceptions. Okay. Because I'm not there just to listen to them and, allow them to continue with their biases, with their prejudices and all that. So I'm going to ask both of you, like if I'm talking to Kalpana, this is what you shared with me about what Shaili said or did. I just want to check with you. Could it be that Shaili did not mean it in this sense? Could it be that Shaili meant something else? Could there be some misunderstanding? Could it be maybe the way she said it has upset you or hurt you? Is it possible? Now, what I'm doing is I'm making Kalpana to think. Kalpana may be too angry to think now, but she will one day start thinking. Or she may immediately start thinking, yeah, it's possible, right? So if I'm lucky enough, Kalpana will say, yeah, that's possible. Let me think about it. Now I leave Kalpana to think about it for some time. Okay, then I come back to Kalpana and say, Kalpana, have you thought about that? And what do you feel? Now, does this help to clarify things to you? So I challenge those perceptions. Okay, I do some reality checks also. I ask Shaili that, Shaili, this is what you're asking for. I just want to understand from you, what happens if this goes to the court? Have you checked how the court is going to look at this? Have you discussed this with your lawyer? If the lawyer is there, very helpful. Sometimes you need to have private sessions with lawyers also. I had a case where, this 5 crores was being claimed as permanent alimony by the lady because the husband was employed in a foreign company and he was earning a huge salary. And the lawyer had assured her that we can get 5 crores. Now, I had a private session with the lawyer and I said, sir, please help me to understand this. Is there any reciprocal understanding or treaty between India and that country where you can execute the decree there? He said, I don't know. I said, I'm asking you purely from an academic point of view, sir. It's just a matter of interest for me. Would you like to find out that? He comes back the next day and says that we cannot execute the decree there. So now what do we do, sir? He says, I don't know. You tell me what to do. I said, look, can you help me to talk to your client and perhaps reach some, understanding where her claim can be a little more reasonable? It's something that, the other side also may not feel bad about giving. He said, yes. I said, I need your help with that. He said, I'm all willing to help. So we go back to the party and we talk to the party and the lawyer also helps me in this and we come to an understanding. Okay, it gets settled for 25 lakhs. Okay. Which was a perfectly reasonable amount because actually the girl was wanting to get out of the marriage. For her, the money was not important. It was the father who was driving her. Okay, and the lawyer had assured her he can get 5 crores. So she was happy with the 25 lakhs. Okay. So this is how things work in a mediation. So you challenge their perception. You check the BATNA, the best alternative. What happens if you walk out of this today? What are your alternatives? Oh, I can go to the court. I have a very strong case. I will immediately get it. That's very good. Excellent. Now, how long is it going to take you? How much is it going to cost you? Have you thought about all these things? I'm not discouraging you, but I just want you to think about it. Okay. Is it really a feasible alternative for you? Just think about it and tell me. Invariably, they think about it and come back and say that, no, let's go ahead. Okay. So I do all this. I have understood the issues now. Now, from the information gathering stage, the next stage, the third stage is the negotiation stage. Now, here again in the negotiation stage, you have an option of doing it in a joint session. You have an option of doing it in private sessions. Now, there are advantages, there are disadvantages in both. The advantage in doing it in a joint session is the offers are being conveyed directly to the other party. And the other party is hearing it from that party's mouth, what exactly they're offering. So you don't have the trouble of explaining the offer. The problem there in doing it in joint session is oftentimes parties don't want to make concessions in the presence of the other party. They don't want to make offers in the presence of the other party, simply because they feel that the other party may take it as a weakness on their side. Or they might be too angry or too, they may feel it beneath their dignity to make an offer. So from that perspective, it helps to do it in a joint session, private sessions. But there, what happens, the challenge is you have to understand the offer clearly, for which you need to test the offer. And don't always confine yourself to one offer. William Ury and Roger Fisher, they're getting to yes say that generate multiple options. They say that you can talk to the party and tell them that, okay, this is what you're offering now. Let us make a note of it. Now let us look at other options. Can we think of some other options? Can we think of something which will be more workable, something that is better than this? Do the brainstorming. Okay, so the negotiation stage takes some time because you don't rush the moment, oh, I'll pay 10 lakhs. Now I go and tell the other party, he's willing to pay 10 lakhs. Now the other party is going to say, who the hell is he to pay me 10 lakhs? I want nothing less than 1 crore. Okay. Or the other party may say, okay, he's saying 10 lakhs, where is he going to get the money from? It's nonsense. He's telling lies. He cannot fulfill that. So what I need to do when I get that offer of 10 lakhs is I need to test that offer. If supposing Thangachan is telling me I'm willing to pay Shiraz 10 lakhs, I ask Thangachan, well, that's good, Thangachan. I hear that you want to pay 10 lakhs, but please help me to understand this. Where is that money coming from? Have you made arrangements for it? Have you got that money in your account? Is there anybody who's going to fund you for this? Or who's going to give you the loan or money or anything? What is it that? And Thangachan also tell me, when are you going to pay this? Okay, are you going to pay it in the form of a check, or are you going to pay it in some other form? Or you're going to put it in the form of some service or whatever. I'm going to ask him, how are you going to pay this? I'm not going to, the reason is to understand what Thangachan has in his mind. Because tomorrow, if I go and convey to Shiraz that Thangachan is willing to pay you 10 lakhs and Shiraz says, I want everything in cash. Now, I don't know what is the form in which Thangachan is going to pay. So I come back to I have to come back to Thangachan. Oh, he wants cash. Oh, sorry, I can't pay cash. I can only pay a check. Or I can do a bank transfer. Now we are stuck again. So I check with Thangachan how he is going to do it. So I generate multiple options. I make a list of the options. I test each of these options. Is it a specific offer? It's called the SMART test, S-M-A-R-T. Is it a specific offer? Is it measurable? Is there a quantity to that? Can it be quantified? Is it achievable? Is it realistic? Achievable in the sense, how can the party really fulfill this? Is it realistic? Sir, if my wife comes back to me, I'll take her on the moon, sir. It's not realistic, right? You're not Richard Branson or Elon Musk. So what are you talking? Okay. So you need to test whether it is realistic and what is the time frame, time bound. Offer has to be time bound. So I do these tests and then I take the offer to the other person. I take it to Shiraz and say that, look, Shiraz, this is what Tangachan is offering. Now, Shiraz has three options. He can either accept the offer, or he can reject the offer, or he can make a counter offer. Partly accept or partly reject, or he can make a counter offer. Now, I get the offer from Shiraz, I do the same testing, then I bring it back to Tangachan. Now, this process goes on. This is the negotiation stage. Okay. Now, yes, Shaili, any question?
Yes, sir. Sir, as we have a prescribed time for the arbitration, like we can get the relaxation from the court for the further time, but still we have some duration for completing the process. So do we have in this as well some duration to complete the process?
See, if you look at court annex mediations, Shaili, court has prescribed 60 days time, which can be extended up to 90 days. Okay. Now, the Mediation Act, the draft bill that we saw also prescribes something very similar. Because the objective of prescribing a time limit is that parties should not use the process to just prolong things. Okay, to delay and protract. Because many times we have seen in court annex mediations, if there's an inconvenient bench. Okay. If supposing the lawyer feels that this judge is not good enough for this case, or maybe will decide against or has a view on this matter, they ask for mediation and they wait till the portfolio changes and then they take it back. So realizing this, the court has given some time limits. Okay. But normally what happens in other jurisdictions, like if you go to the US or the UK, they enter into the mediation room in the morning and they come out in the evening with an agreement, or they come out the next day with an agreement, or it may extend to a few days. Okay. But usually mediation can get over within a matter of days. It doesn't take long because there's no adjudication, there's no letting in of evidence, there's no trial, there's nothing. It is just a negotiation. And it all depends on the convenience of the parties and the convenience of the mediators. It's a very flexible process, so you can finish it very fast. So actually time limit becomes irrelevant. Okay, it's all about just fixing the time and doing the job, that's all. Okay, so coming back to this, so once you have reached an agreement, now there are two possibilities. One, you may have an agreement, you may not have an agreement. Parties may not reach an agreement. Now, either of these things happen, you go to the closing stage. In the closing stage, what happens is, if you have reached an agreement, normally we, as a matter of principle, mediators don't draft the agreement. Now, the purpose of not drafting the agreement is because it is the parties' agreement and it should be written by them. So if they have lawyers, it's very convenient because lawyers then prepare the agreement. If they don't have lawyers, you can assist the parties in writing down the agreement. Okay. So normally we don't draft the agreement for the parties because any mistake that you make, anything that you may have misunderstood or the parties have understood in a different sense may lead to conflict at a later stage. So as far as possible, it is in the parties' language, how they understand it. And each and every word, once they have written down, you read out, you confirm whether they have understood it in the same sense. It's not easy. You don't just rush into the agreement. You have a draft agreement, you get them to sign it. No, this itself takes a little time. because you have to spend the time with both parties. And this is always done in the joint session, the closing stage. So once you have the agreement, they sign it, you thank them, and the process comes to an end. And never forget to collect your fees. Okay. So basically, to sum up, the process is one, the convening in private mediations, usually where you decide on the venue, where you're going to meet, whether it is going to be online or offline. Okay, all this happens sometimes on the telephone or through exchange of emails. Okay, then you have the agreement to mediate that you enter into with the parties, where you discuss the terms and what are the fees and how it's going to take place and what etiquette they have to follow, all that you put down. Then you have the mediator's opening statement. Now, many times mediators say that, okay, because we have an agreement to mediate, why should we have an opening statement? Okay, but I insist that we should have an opening statement for the simple reason that a written word can have different interpretations. Now, I always give this example. If you can just write down this sentence, I never sold that horse to you.
What's that? Please repeat, no?
I never sold that horse to you. Now, to each one of you, this may convey a different meaning, correct? Or it may convey multiple meanings if you read it. It may mean for you that when I'm saying, I never sold that horse to you, it was somebody else. Okay? I never sold that horse to you. It's not my business to sell horses. I never sold that horse to you. I gifted it to you, or you stole it from me. I never sold that horse to you. I sold a black horse. And now you're pointing out a white horse. I never sold that horse to you. I sold you a donkey, or a cow, or a buffalo, or whatever, or a bull, not the horse. I never sold that horse to you. I sold it to Yasmin. So you see different meanings, okay? So when you have the written word, always make sure that that is understood in the same sense by everybody. Okay, because it is capable of being interpreted, and that is how we lawyers thrive. Okay, because people tell me many times when I became a lawyer, one of my uncles said a couplet in Urdu, which essentially meant that, I don't know how many of you understand. So he said, Paida hua vakil. When a lawyer is born, Shaitan ne kaha, Satan said, Lo aaj hum bhi sahib aulad ho gaye. Oh, I have a son now, okay, or a daughter or whatever. I have progeny. So we are always perceived as people who lie. And I always say we don't lie. We look at things from different angles. We interpret things differently. So a written word is capable of the same act, the same section, two different lawyers will interpret it in two different ways. And finally, the judge's interpretation prevails. So always make sure that when you're preparing the agreement or when you're having an agreement to mediate, in your opening statement, cover all those points so that parties have understood it in the right sense, in the same sense. Okay. So we have the convening, we have the opening statement, we have the information gathering stage, okay, where it is very comprehensive. You do a whole lot of things in that process. You understand the issues, you identify the issues. Then you have the negotiation stage, and then you have the closing stage. Okay, so these are the stages of mediation, and this is how the process works. So now I'm open to questions. I have a mediation at 8 o'clock today. It's an online mediation. Parties are from US. So we have half an hour more. So please feel free, ask me any questions. I saw a lot of questions on the Shravanti has raised the hand. Yes, Shravanti.
Yes, sir. Sir, it's just about, temper of a mediator. See, it's not always possible for a mediator to, control his negative emotions such as anger or irritation. But there is also a way that we definitely recognize it. And how is it that we have to put up, project ourselves despite of so much of irritation? Because end of the day, we are also humans, and we tend to show those emotions in one or the other way. So Yeah, so can you please give us some tips on how to carry ourselves? See, not all of us can be patient at all times, right?
Yeah.
Yes.
You're absolutely right, Shravanti. And I also noticed that you consciously or unconsciously used the male gender when you said you can get, mediator can get angry or he can do this or that.
Okay, he or she.
Okay, so it doesn't matter. It's perfectly all right with me. I was just joking.
Yes.
So that's a good question. Now, here's what I can only tell you what I do. Okay, different people have their own way of doing things. First and foremost, let us understand that we are all victims of biases and prejudices, and we have our own perceptions. And those perceptions are who we are, the way we grow up, the environment that we grow up in, the values that we are taught, the notions that we hold, the beliefs that we have. All these are the perceptions that we have. Okay. So we are all victims of that. As a human being, you cannot say you're free of prejudice, you're free of bias, you're free of, you have a very neutral perception. Everybody has that. The only challenge here is being conscious of it. Okay. Now, how do you become conscious of that is first acknowledging that, yes, I have these things, I have these problems, and watching yourself throughout this. Watching yourself throughout this, making note of how your mind is working. Be aware of your mind chatter. Okay. See, I had this case where I was going to the mediation room. I got a call from my friend's wife in Bombay. And she said, there is a matrimonial case that's been referred to you. And I understand you're the mediator. And that girl is my daughter's friend. So please see if you can help her. I told my friend's wife, I said, look, you have put me in a very delicate position now. Okay. So I don't think I can mediate this. So I go into the room and I tell the counsel and the parties that, look, I got this call and therefore I'm withdrawing from this mediation. Now, both the lawyers were mediators and we all got trained together. So they knew me and they said, no, Jawad, we have faith in you. Please continue. Now, what happened in this mediation was that this was in the beginning days of my mediation practice. Okay. After that, that was a big lesson for me, actually. This case was a big lesson for me. In this case, what happened was there were some facts that came to light about how this lady was ill-treating her 5-year-old son. Okay. At that time, my grandson is 13 now, the elder guy, and the younger guy is 12. But at that time, they were 5 and 4. Okay. So when I heard this, I don't know, I was not even aware that I was thinking that how could this lady do this to the child? When I think back on that, I realized that, yes, that thought occurred in my mind. Now, I didn't tell her anything. I didn't look at her accusingly, or I didn't even, but perhaps I didn't smile at her, or perhaps my attitude towards her changed without my being conscious of it. She told me, I think you don't like me. After a few sessions, that too, not immediately. After a few sessions, she said, I don't think you like me. I think you're biased against me. I said, well, I don't really know about that, but thank you. If that's what you feel, I think I should withdraw from this mediation. And I told her that please go and ask for a change of the mediator. And she went and asked for a change of the mediator. Okay. So you see how, now I'm very conscious of that because that was a lesson for me. And now I always consciously think that this is not my problem. Okay. If somebody's now, I was very recently I was doing on mediation where the husband had installed cameras. He was a doctor. He was practicing somewhere else. Every weekend he used to visit home. And this girl was a very petite, very pretty looking. She was an architect. Okay, but he didn't allow her to work. And he had installed cameras in the living room. He was so suspicious. Her contention is he's suspicious. His contention was because I want to see my children and my wife, because I'm far away and I'm working the whole week. I don't get to see them. This helps me to keep looking at them. So this was his explanation. Throughout this process, I was completely neutral. There was one intern who was sitting with me. Okay, the parties permitted an intern to watch the process. So she was sitting with me. And the parties left. She asked me, So how could you not get up and give that poor girl a hug and tell her, so sorry that this is happening to you? How could you not do that? All the time I wanted to just get up and hug her, she said. I said, well, I'm the mediator. I'm not supposed to do that. Okay. I can't take sides. So now I'm very conscious of that. Okay. I'm very careful. So this is something that you have to consciously work on, and meditation helps you a lot.
Yes, sir.
Okay? I make it a point to meditate at least 30 minutes every day. Okay. Just to be aware of myself. Okay. Anu, don't look at me like that. Okay. So
Thank you, sir.
that's my wife. Anis Jawad is my wife. So she's watching me. So I become very self-conscious when she's there. So I'm very careful, to be very aware of how I'm feeling at that time. Okay. Too strongly, I withdraw from mediation. Any other questions? Yes, Shaili.
Yes, sir. So we usually face some issues during online sessions and online things, like a person like me who's not so comfortable on the screen. So, sir, what are your experiences related to e-mediation? Like, what are problems, and like how you came up with the solutions regarding the same?
Well, it is a bit of a challenge doing mediations online because one, you're not able to observe the parties fully. Like you can only see their faces. And also, when you want to build trust and confidence with the parties and you want to, show your empathy towards them, you have to be very conscious of your facial expressions and your tone of voice, because these are the only two things they see. Okay, because they're not able to see your hands. They are not able to see the rest of your body. They don't see your body language. You're not able to see their body language. So this is a disadvantage. But what I have experienced, I'll tell you what. I did this mediation course for Maharashtra National Law University. They have a course of MA in mediation. And the very first paper is Basics of Mediation, where I teach them the process, the stages and all that. So this lasted for about a month because, they were all professionals, very senior professionals, CEOs and all that. And so we used to have 1 hour a day or 2 hours a day, 3 hours a day, like that. So it lasted for 1 month. But what was very interesting was it was completely online, but we developed such deep connections and bonds with each other that when I went to Bombay on a visit, it was pouring rain and I was staying somewhere very far away. And all these people came in that pouring rain to meet me. I mean, you can imagine the kind of connection, that kind of, rapport that we had developed. Okay. So I don't believe that, don't you feel connected to me now?
Sure, sir. We are feeling very connected to, so I am asking so many questions in that half an hour.
Yeah. See, so exactly, that's my point. Okay, it all depends on how you ultimately conduct yourself in an online proceeding. So it depends on how you are able to develop the rapport. I hope I was able to do that. And thank you for being so nice as to say that, yes, you did. It makes me feel happy. I don't know whether I really did. But anyway, it feels good. Thank you. Yes, Yasmin?
So first, my question is that whenever we are doing mediation, do we need a lawyer with our parties, or? And second is, like when both the parties are only agreeing, and you said that they only draft the agreement and they'll sign, we are not supposed to draft. Yeah. Then is there any chances to come out of that agreement? How much they will be binding on that agreement?
Yeah, see, my belief, Shaili, Yasmin, is this, that, okay, first of all, let me answer the question on the lawyers, okay? I'm very comfortable if lawyers are there. Okay, why? Because one, it puts the parties at ease. Okay. It makes my job much easier because I don't have to really labor under the feeling, are they taking the right decision? Is it good for them? Because I don't have to really do that as a mediator because it's their decision. But when they have a lawyer with them, who's guiding them, who's assisting them in the process, I have an additional layer of comfort there. That, okay, if they're deciding this, it is in their best interests. Okay, and they must have thought about it because they would have discussed with their lawyer. So it gives me an additional layer of comfort. Okay, so I prefer having lawyers. Sometimes lawyers can be difficult. Okay. Now, many times what happens, like I was doing one mediation where the lawyer was going on raising all technical issues. The parties were doing great. Okay, they were making a lot of progress and they were able to understand each other's point of view. They were able to come up with proposals that were working, but the lawyer kept on coming up with legal technicalities. Okay. So I paused, I told him that, sir, I really appreciate your effort, your sincerity in helping your client. Okay. But here we are not in the court. Okay, all these efforts of yours would be really helpful for your client in the court. But we are now in a mediation. So what we are trying to do with this mediation is to reach a space where both can work with each other to do what is best for them. And in this, they will really be benefited and enriched by your assistance in that. So let's keep these legal technicalities on one side for a minute. Let's think about what is best for them. And then let's see how these legal issues are going to affect them. Okay, I'm willing to discuss it with you. But first, let's get this in place, and then we will talk about that. Okay, so this is how I dealt with a difficult lawyer. Okay, now there are different ways of dealing with lawyers. Okay, like I told you about that 5 crores case. Okay, so I had a private session with the lawyer. Okay, because I don't want to demean him or I don't want to put him down in front of his client. I want him to feel comfortable. Okay, I want him to trust me also, because it's important to gain the lawyer's trust also. And in my opening statement, if lawyers are present, I'm very careful. I tell them that, look, you're very lucky to have these lawyers because they have brought you to the mediation table. Okay, they could have easily prolonged this process and benefited from it, but because they have your best interest in mind and they have brought you, and I look at the lawyers and tell friends, I need you here. Okay, and I'm going to look to you for help. Okay, I will need you to guide me through this process. So you have to satisfy their egos also, because they're all humans. They're like me, right? I mean, I'm also a lawyer. So why should I, put them down? So they feel comfortable after that, and they realize that, okay, first they come thinking that here is another lawyer from the same court who's sitting over there and who can perhaps, point out what mistakes I may have made or influence my client and take over my case. So they come with that. So when I put them at ease, when I tell them that I need you, I need your help, okay? So I need you to guide me in this process. I'm putting them on a pedestal, okay? I'm giving them a responsibility. And they feel important, okay? I recognize their importance, and they are important. It's not that these are not empty words that I'm telling them, I mean it, okay? So they understand that and they cooperate. So what was the second question that you asked, Yasmin?
Like the parties themselves draft the agreement, so
Yes.
whether they are binding.
See, there is every possibility that some development. See, first and foremost, if you have done the process correctly, like for example, you have understood where this conflict is coming from, what their underlying interests are, you have helped them to understand this, you have tested their options, you have tested their BATNA and BATNA, you have done all these things and they have come to a conclusion that this is best for us. They won't go back because it's their agreement. It is not something that I am telling them to do. It is what they have decided. That is what is important in mediation. That is where mediation also differs from other dispute resolution processes, because when it is my agreement, I can't be unhappy about it because it's what I have decided, right? I can't question my own decision, can I? So they don't go back on that because I have tested everything with them. Okay. Now, if they go back on that, it is some deficiency perhaps in the way I have conducted the process. Okay, that is one. Number two is, in spite of all that, something may happen subsequently, which will force them to go back. Now, that is where the law steps in. Okay, the law steps in and says that once a mediated agreement is reached, a mediated settlement agreement, hopefully the Mediation Act, that's what it says. It is like an award or a decree of the court. So it's executable. So if one party defaults, the other party can go for execution.
Yes, sir. Thank you so much, sir.
Thank you. Any other questions? I saw a lot of questions on the chat. Can somebody... Pankajchan, can you help me on this?
Shaili, please check the chat box for any questions.
No, sir, there are no questions.
No, there are some questions, I think, in the
There's written thank you only. I think
Yeah, I think there are a lot of statements there.
Yeah,
Sir,
statements are there.
So, Ms. Ravanti Premkumar has asked,
Huh.
how does a mediator control his/her red flags when the parties meddle with the certain negative emotions?
I think she asked that question, Saraz, that has been
Okay.
clarified.
Okay.
Yes, sir. Yes, sir. It was already clarified. Thank you.
Okay. Okay.
And I think Akshat has asked some question. Akshat, you can go back, then you'll find that question. In mediation, role of third parties merely to act as a bridge for communication and letting it is there.
so
Shaili,
that's answer regarding some questions I have asked previously when he was
yes,
saying something.
okay,
All the upper chats are answers.
okay.
One recent question is there. No, sir, that is only the thank you disclosure. No question.
Shaili, there is a question by Harshita. I can see. Is a mediator to be a lawyer? Should the mediator always be a lawyer? Harshita's question.
Harshita, let me check, ma'am.
Yeah, Harshita has asked a question. Should the mediator always be a lawyer? My answer is a firm no. It need not be, because yes, lawyers are essentially dealing with disputes, therefore they're in a very good position to be mediators, but it need not necessarily be that. Okay, it can be from anybody can be a mediator as long as see, I strongly believe in process expertise. Okay, I believe that if a mediator is well trained and equipped to handle the process correctly, anybody can be a mediator. Now, where domain knowledge is concerned, domain expertise is concerned, like, for example, if you're dealing with a particular subject, okay, you're mediating in that subject, a little bit of knowledge in that is definitely helpful. Okay, like in one mediation, a mediator asks the parties, what is a letter of credit? Now, that shakes the party's confidence in the mediator. They feel that he doesn't know anything. Okay. So that kind of a little bit of domain knowledge may be necessary, but domain expertise is something that I'm a little concerned about, because what happens when I'm an expert in a subject, I know the answers. Okay. And I'm too eager to express my knowledge about it, my views about it. Okay. Now that what happens is it dilutes the self-determination aspect of mediation. Okay. So you can always enlist the help of an expert. Okay, you can have, supposing you're dealing with, let's say, mediating a case of medical negligence. Okay, you can always opt for a co-mediator who might be a specialist in that subject. Okay, you may have a co-mediator. But what I'm trying to tell you is, since you're not deciding anything there, okay, what is more important is how you conduct the process, how you guide the parties through the process so that they understand what is happening to them, what is happening with them, why it is happening, and what they should be doing about it. So if you're guiding them through that process, your process expertise is more important. Therefore, whether you're a lawyer, you're a doctor, you're a chartered accountant, you're a homemaker, you're a auto rickshaw driver, whoever you might be, you know, many years back, like 40 years back, when I was not even in law college, one of my uncles had a problem in Vijayawada. Okay, there was a business dispute between him and his partner. And in that particular area, there was one mechanic who used to repair radiators. Okay, and he was the person everybody used to go to with their disputes. And I had the opportunity to accompany my uncle over there. And you know, that time I did not know what exactly he was doing. Okay, because all I knew was that he came, first he bowed before the picture of the deity, then he came, he sat down, he listened to both of them, and he said, now tell me what is important for you. Okay, and they both expressed themselves, and he said, how would you like to resolve this? Do you want to go to court or you want to solve it between yourselves? And they said, that's why we have come to you. And he said, now you tell me how you would like to see this resolved. Where is the sticky issue? Where are you not disagreeing upon? Now, all this was mediation. Now, when I think back on that, that time I didn't know that he was doing this. But when I think back on that, here was a mechanic, an illiterate man who used to repair radiators, who's sitting there and doing mediation. So what makes me think that because I'm a lawyer, I'm superior to him? Right? Some people have those inherent qualities. Why should we disqualify them from that? Okay, perhaps, that is what is called as unconscious competence. Okay, they are unconsciously competent. Now, all we need to do is make them consciously competent. That, boss, this is the right thing that you're doing, and this is how you should be doing it. You're perfectly on track. So show them that, and they're going to be becoming much better at their job. So why should we stop them from becoming mediators? All I'm saying is, let us have some standards. Let's prescribe some, basic fundamental things like what qualifications or what kind of qualities a mediator should possess. Train people and certify them and allow them to do mediation regardless of where they come from. Shaili?
Yes, sir. As whatever you're saying, so with that regard, is there no specific qualification of a mediator and a lawyer who is being a lawyer for the session of the mediation? So is there any specific qualifications to be a moderator or be a lawyer of the sessions?
See, right now, Shaili, we have this so-called 40-hour mediation training. Okay, now some people do it for 60 hours, some people do it for 80 hours. Now, this 40 hours or 60 hours or 80 hours is not a magic wand that you wave and people suddenly transform into becoming mediators. Okay. I underwent basic mediation training about 15 years back, and it has been a continuous journey of learning after that. Okay. When I think back on the kind of mediations I used to do before, I sometimes, feel repulsed. So what the hell was I doing? So you keep learning. Okay, you keep learning, you keep developing. And it is a process of learning. Okay, now what we do in this 40 hours, why it is important is because it simply puts you on that journey. It makes you aware that how many of us know that, active listening is something that exists? How many of us know that there is something called emotional intelligence? Right? We know, we may know, but how it is applicable to conflict, how it is applicable to disputes, how you can utilize those techniques to help people to resolve their disputes, right? So that we may not know, right? So even we may know, we may have segments of knowledge. Now, how to collate all this together and put you on that path, that this is your starting point, you're starting on this journey, keep learning, keep progressing, keep developing yourself, keep evolving as a mediator. Okay, evolution of a mediator is a never-ending process. Each experience gives you a new perspective. It gives you a new facet. Okay, so you keep learning. Yeah. Sorry, 1 minute, Shaili. I'll come to you. I think Shravanti has got her hand up.
Yes, sir. I have a doubt. Now, this is regarding appointment of an expert co-mediator during the proceedings. Obviously, we have two parties to a dispute. Is there any procedure that we have to follow, like asking the permission of the party? Yes. Because that is essential, right?
Their consent is absolutely necessary. Without their consent, you can't appoint anybody. Okay, because they are going to be paying for the co-mediator also.
Okay.
Right? They have to consent for that.
Okay.
Shaili, you wanted to say something?
Yes, sir. So by the time the involvement of the mediation is we are seeing the involvement of the mediation is very high nowadays. So why do we not have such procedure or such a course or program that can help us to be a good moderator or a good lawyer in the mediation session?
Yeah. See, there are courses now, Shaili. We have different courses which many institutions are offering, okay, which train you in this. But see, the problem here is this again, because there are limitations, okay? Like when you study 3 years or 5 years of law, when you come out, you're not really a lawyer, right? Though you may be enrolled with the Bar Council, but you still are on a journey of learning, right? And with more and more experience, you become better and better. So always any kind of training or any kind of education is only a starting point. Okay. So there are courses which you need to do, which make you aware that how does this process work? Okay. Like for example, what kind of questions you ask? Okay. If you want to tell somebody that you're absolutely wrong, how do you do that? Are you going to tell them that, hey, look, you're wrong? Now, what happens when you tell somebody you're wrong? There is something in emotional intelligence, in neuroscience, that is called a scarf. Okay. Now, this is something that you need to know basically. Okay. So once you understand that, you know how to formulate your question. Okay. Well, you have a very interesting perspective of it, and you have your own way of looking at it. Can we also see whether there are other perspectives or other ways of looking at it? This is how I would put it, because I don't want to hurt the person. I want to respect the person. Okay. So this is how we do it. Yeah. Just give me 1 minute because the other mediation is going to start. Yeah, sorry. Any other questions? Okay, we'll have to call it a day now because thank you very much for your patience and for listening to me. Just 1 minute, 1 minute. Yeah. Where is my? Yeah, sorry, Shaili, go ahead.
Yeah, no, sir. It was just I was thanking you for this wonderful session. Like you have attempted all the questions that we have regarding this, and like it was very interesting session. So thank you so much.
Thank you, Shaili. As long as I didn't put all of you to sleep, I'm happy.
I have one statement to make. That's what I understood. You started with Stone Age, and you were asked what is the difference between litigation, arbitration, and mediation. So what strikes to my mind is arbitration is more like an artificial intelligence because we are moving technically towards the technology part. But when it comes to mediation, what I feel is it's not artificial intelligence, it is involvement of human, emotional, intellectual, is what I feel so. So is that appropriate or understanding?
You're absolutely right. You're absolutely right, Kalpana. Somebody asked me this question in a webinar. They said that what happens if can AI replace mediators? I said, I don't think mediators can be replaced by AI for the simple reason that if I'm talking to somebody and if I'm showing empathy, that person knows that I can feel that feeling, okay, because I'm capable of feeling that feeling. Whereas if IBM's Watson tells you that you look upset, you're angry, I know that Watson cannot feel that, okay. And I said, as long as I cannot take Alexa on a date, I'm absolutely. Okay, thank you. I'll really have to sign out now. I'm really grateful to all of you.
Thank you, sir. Thank you, sir.
Thank you so much, sir. Thank you so much. It was really a smart class, sir. It was a smart class.
Thank you, Push.
Thank you so much, sir. Thank you. Thank you, Shiraj sir. Anish ji, thank you. Good job done, Shaili. Keep up.
Yeah, Shaili, great job. Thank you. Congratulations.
We have Pramila ji, Hari
Shaili, you have done
sir,
a wonderful
Rajesh ji,
job.
Sonal.
He was
I
very
think we have
active.
Gitanjali also with us today.
Pushpa, I'm leaving, huh? Thank you.
Okay, sir. Thank you so much, sir. Truly grateful, sir. Thank you so much. Thank you.
So, with your permission, let me.
Tomorrow we'll meet.
Okay.
Someone please be ready with some Christmas carol tomorrow. If any student can volunteer and just sing Christmas carol, we'll be more than happy. Huh? Okay. Bye-bye.
Thank you,
Push. Take care. Bye, Anish ji.
Thank you.
Thank you. Thank you. Bye. Bye.
Bye. Take care.